The scroll of your name, please.
My name is what you asked for?
I did.
No, I'm not Peyton Ansley John Milton. I'm the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
And how do you choose to go forward?
Pro se, please.
Okay, you even know the right term, okay?
And there's no victim in this alleged crime. I might preface this with, I have gone to anti-kidnapping training. I was inhumanely subject to what I would define as torturous actions.
All right, guys, buckle up, because today we're dealing with one of the most clueless sovereign citizens to ever set foot in a courtroom. This guy seriously thinks he's cracked some legal cheat code, spouting the same tired nonsense like it's going to magically erase his charges. Spoiler alert, it doesn't. The judge? He can't help but laugh. And honestly, neither can we. I mean, how do you argue against reality with that much misplaced confidence? At what point do these people realize the law doesn't care about their made-up rules? It's honestly wild how far gone some folks are. So here's a challenge for you. As you watch, drop your guesses in the comments. What do you think this guy's IQ is? I'm putting it somewhere between room temp and refrigerator level. All right, let's jump into this train wreck.
And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself in my sovereign capacity. Appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt. I'm letting you just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented. Thank you.
As the agent for Peyton Ansley John Milton, you are indicating to me that you're quite familiar with Peyton Ansley John Milton, and that's basically you. Is that correct?
I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
All right. And you understand, for my purposes, though that language doesn't make any sense. So
no, I do not.
I understand. Okay. Well, I'm telling you that. And so I am, until you disabuse me of the motion or the notion, I am inclined to believe that you are both the agent and the person. So, and it's
I'm not a person. I am one of the people. Thank you.
Okay. Thank you. All right. So for the record, that's my finding. Yeah, hold on. We're not done.
Okay.
Have a seat.
You got it.
And thank you. Mr. Sharp, let me swear you in. Swear the testimony and probable cause application be the truth, whole truth, and nothing but the truth.
I so swear, Your Honor.
Okay, Mr. Sharp.
So this information comes from a report of Officer Evers of the Lacey Police Department. She responded to an unwanted person complaint at a 7-Eleven store. Upon arriving, Officer Evers contacted staff who advised her that it was a white male, approximately 5'5", with a beard, wearing green long-sleeved flannel. Staff advised that he was intoxicated and belligerent. At one point, the male stated he would be waiting outside when they got off work, that they asked the male to leave multiple times and he refused. Once they called the police, the male returned to his Toyota 4Runner, that it was parked outside the gas station. Staff stated that they didn't feel safe, wanted the male trespassed. Officer made contact with the male and immediately was able to identify him as Peyton Milton. Officer knows Mr. Milton is a local transient that lives out of his car, has had several social contacts with him. Officer Evers asked Mr. Milton if he was just inside the store. He stated that he was. He stated that he was too drunk to be held accountable.
Of all the excuses out there, this sovereign citizen really said, "I'm too drunk to be held accountable." Not denying the crime, just admitting it and blaming booze. You can't make this up. These guys really think if they throw out enough nonsense, the law just taps out. Drunk at 7-Eleven, caught red-handed, and somehow still claiming victimhood? It's wild. Honestly, it feels like they all took the same bogus Reddit course on sovereign rights and ran with it. Let me know in the comments. Are they clueless? Or just playing dumb? Either way, it's about to get even messier. Let's dive back in.
Officer advised Mr. Milton that he'd be trespassed from the 7-Eleven, and he stated, "I understand what you have to do." Mr. Milton offered to manually push his car to a gravel lot about 25 yards from the 7-Eleven so that he wasn't on the property, since he was too intoxicated to drive. Officer agreed and gave Mr. Milton until nightfall to push the car out of the lot. Officer provided Mr. Milton with his phone, and he replied, "Can I go back in and charge it?" The officer advised him that he could not charge his phone at this 7-Eleven and that if he entered the store again, he would be arrested. Officer provided Mr. Milton with a copy of the trespass form. And then at 16:23 hours, staff called dispatch advising that Mr. Milton was back inside the store. Staff advised that Mr. Milton said he was too drunk to be held accountable, and that he left again once they called dispatch, and this time he again left his cell phone in the store. Officer then contacted Mr. Milton. He again stated that he was too drunk to be held accountable. Officer noted that Mr. Payton was intoxicated but functional and able to understand the officer's instructions. Officer advised Mr. Milton that he was under arrest for trespass, detained him without incident. He was then booked into the county jail. The Nisqually jail.
On the charge of criminal trespass first degree, is the city making a motion to revoke the deferral on the assault conviction or
Yes,
on the
Your
assault case?
Based on the new law violation, yes.
Thank you. And let's see.
Now, will I get a moment here to articulate anything?
I'll let you know. So sit
Appreciate
tight.
it.
I'm still working through the process. Thank
Of
you.
course.
All right. So, Ms. Sharp, it appears that the assault was not a deferral. It was a stipulated order of continuance.
That's correct, Your Honor.
All right. Thank you. So we'll note the city's motion to revoke the continuance on the assault charge based on the allegation of a new law violation. And Mr. Milton is asking not to be represented by counsel. Is that correct?
That is correct, Your Honor.
Okay, so let's have a little chat about that. If you choose to represent yourself, which is your right, you can make that choice. But I want to make sure that we make a record that you are doing so knowingly and voluntarily. Ms. Langley is an attorney. I'm going to guess that you have not gone to law school and become a member of the bar. Is that correct?
I can neither confirm nor deny that information, actually.
Okay. So not being an attorney, you understand that if you represent yourself, the court cannot assist you in recognition of the fact that you're not an attorney. So you will end up missing things you're supposed to do. You will do things you're not supposed to do. And all of those things will likely work to your detriment. So it is never a smart thing to represent yourself. And frankly, if an attorney were to say they would represent themselves, I would have the same conversation with them and advise them, I think it's a foolish decision to make. You, however, have that right, as I pointed out. But I want to make sure you understand you have the right to have counsel. You have the right to have me appoint counsel, or you can hire counsel. And if you ask me to appoint counsel, I can appoint counsel at no cost. So you understand all of that.
I appreciate that, and I do. Thank you.
And how do you choose to go forward?
Pro se, please.
Okay.
Your Honor.
You even know the right term. Okay.
Your Honor,